Hello again, my name is Eric Willison, and this is Fatlock on Evidence. We're going through the rules of evidence so we can teach you all about them. We've already been through the basic rules about what relevant evidence is, and the rule is that relevant evidence comes in unless there's a rule against it. Sometimes we've been through Rule 403, and now we're getting into hearsay. Hearsay is a rule that does not let certain types of evidence in if it's an out-of-court statement used to prove the truth of what it's saying. Now, there are exceptions to hearsay rules. We're almost there. Got a very, very short video, one last bit before we get into the rules that provide the exceptions to what is hearsay, when those out-of-court statements actually can come in. But we're going to go through just a few last things that aren't hearsay. So remember, there's a difference between things that aren't hearsay, so they can come in, and things that are hearsay, but they can come in because there's an exception. These are not exceptions, what I'm talking about here, okay? These are things that are not hearsay, even though they sort of seem like hearsay, but they can come in. So the first thing we got to talk about are what are called non-assertions. That they seem like assertions. They seem like you're trying to say something out of court and get it in, but these are actually non-assertions. One of the most common examples is what's called the statement of an animal. Now you're thinking, what? How can a statement of an animal come into court? Well, we see this all the time, actually. The police bring the drug dog out and sniff the car, or they sniff the locker, or they sniff the container. And then the drug dog does what it's trained to do when it detects the smell of a certain type of drug or a certain type of explosive or whatever. It will either maybe jump up and scratch it, or it'll sit down right next to it and then look at the police officer or whatever. That is saying to the police officer, I smell drugs in here. So, as an attorney, your knees start twitching and you get up and say, objection, Your Honor, objection. That's an out-of-court statement from the dog. Wait a minute. The rule is dogs can't make statements, okay? This is just the dog's training, okay? We are viewing the results of the dog's training. The dog isn't actually trying to say something. It just knows that when it smells X, it does Y. Okay, this could be a mechanical device, and if you wave it in front, and when I was in the Air Force, we had these chemical tapes, and you put this tape out into the air, and if it turned a different color, that means you had a certain chemical in the air, and you better not be breathing it. Okay, so this is the same way with the dogs. The dog smells marijuana, or it smells cocaine, or it smells C4, dynamite, whatever it's trained to smell. It's alerting to the presence of this and then doing its thing. The dog is not actually saying anything. This is just the result of its training that we're looking at. So what an animal does in relation to its training is not hearsay because it's not an actual assertion. It's just a reaction to its training. The same thing is true when we talk about the results of a machine. Let's say you get the calculator out and you type in 4 times 6, and it yields 24. And then, of course, the attorney jumps up and says, well, now, wait a minute. You're telling me that 5 months ago you typed in 4 times 6, and it was 24? That's hearsay from the calculator. No, it's not hearsay from the calculator because it's a mechanical process. Okay? Your Honor, I got on Google and I typed in interesting places in Paris, France, and it came back with the following places to go. Well, yes, the computer, it seems like it's making an assertion as to what the interesting places are to go in Paris, France, but it's not really. An inanimate object cannot make an assertion. It's merely a mechanical device that is spitting out, or in this case, a digital device, that is spitting out a result based upon its, I won't say training like the dog, but it's programming. So when you've got a mechanical device, the thermometer says it's 20 degrees. Well, it's not hearsay because the mercury rises in the thermometer to the 20-degree mark, and there you are. So the thermometer isn't saying anything. It's the person that goes and looks at it can discern that it's 20 degrees because that's as high as the mercury inside the thermometer rose. So this is just a bunch of wires and processes yielding a result, just like the dog's training yields a result in the earlier example. And now lastly, I told you this is going to be a short video. Lastly, remember from our opening videos of this series that a witness can only testify to what he or she saw, smelled, felt, tasted, heard. You can't testify as to what happened during the Kennedy assassination unless you were there that day. You can't say, oh, well, I read in a book that such and such. No. That's hearsay, okay? The fact that you saw videotapes of it and the fact that you read a book about it does not mean that you can testify about what happened. Now, this requirement of having firsthand knowledge, that you did the perceiving, whether that perceiving again was hearing, smelling, tasting, feeling, seeing, if you did the perceiving, you can testify. It seems a lot like a hearsay objection. Because obviously what other knowledge are you going to have except for somebody else, some other work, some other movie or a book that you read. But it really isn't necessarily hearsay. The objection here would be that you don't have actual perception of what you saw or you heard. So in those situations, you get up on there and you talk about the Lincoln assassination and somehow that bears upon the case. I don't think you can testify unless you're an expert, because that brings in a whole different consideration of other things. But as a lay witness, meaning a non-expert witness, you can't testify to what you didn't perceive. Okay, so it's sort of related to a hearsay objection, but it's technically not a hearsay objection. So it's related to the concept, but that's all it is. So that's all of what we have for what is hearsay. And the next videos are going to discuss when it's hearsay, it can still get in if it falls into a certain limited number of exceptions. I'm Eric Willison, and this is Fatlock on Evidence.